Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
Hello, and welcome to the Serious Privacy Podcast, where our goal is to get the information you need at a time that's most convenient to you. Now, one of the wonderful things we're doing is we're making sure our webinars are available via podcast. And this way you can go online and download the materials and claim your 1 hour of CPE credit, but you can listen to the podcast at a time that works for you. Now, the link to the resources is down in the description. But just so you have it out loud, it is our website, trustarc.com/resources/privacy on demand webcasts. And webcast is plural. Those last 4 words, privacy on demand webcast, have hyphens in between them. So please make sure you go get the materials. And this webcast is on the new Turkish Data Protection Law. Is it the new GDPR? It's hosted by my co-host Paul Breitbarth, who is featuring 3 preeminent Turkish law experts. Take it away, Paul.
Good morning, good afternoon, good evening, wherever you may be, and welcome to this first TrustArc Anonymity webinar for 2020. Today, we will be discussing the new Turkish Data Protection Act. Albeit new, the legislation has, of course, been in force since 2016, but it now really becomes serious because of the notification requirement going into force later this year. It was actually already expected when we scheduled the webinar to be live by this time, so we wanted to make sure that you are well aware of all the compliance requirements under the Turkish Data Protection Act, and we'll also take a look at how it reflects to the GDPR. My name is Paul Breitbarth, and I'm TrustArc Anonymity's Director for EU Policy and Strategy. I'm based at our office in The Hague in the Netherlands, and for those of you who are not familiar with me, I come from the Anonymity side. And as you may be aware, TrustArc Anonymity have joined forces last November and will go forward as one company as of this year. I'm very happy to be joined by a number of Turkish friends to give you all the details on the webinar on the Turkish legislation during this webinar. And I'll ask each of them, Bora, Kaan, and Haki, to introduce themselves. Bora, please.
Thank you, Paul. Hi, this is Bora from Dentons Istanbul. I'm a qualified lawyer in Turkey, and I'm the counsel dealing with regulatory and compliance issues in our Istanbul office. And I'm mainly involved in leading teams for Turkish data protection compliance of our clients, and also assisting our clients in their day-to-day questions about Turkish data protection rules. Kaan?
Hi, everyone. I am Kaan Dora. I am the head of IP and Technology Practice Group in Istanbul BASEK office. I hold the certificate of CIPM and practicing personal data protection law since the last 8 years in Turkey. We are also conducting compliance programs for our clients in Turkey, and happy to be with you here. Hakkı?
Thanks, Kaan. Hi, this is Haki. I'm a senior associate in the London office of Dentons. So I'm duly qualified in both England and in Turkey. I had practiced law in Turkey between 2006 and 2017, and during the 5 last years of that time, I was the head of TMT and data privacy practices of another leading international firm. And since January 2018, I am a senior associate in our data privacy team here based in the UK.
Thank you very much to all three of you. And indeed, it's good to note that this is indeed a TrustArc anonymity webinar, but we organize it in cooperation with Dentons and Basek Istanbul to make sure that you get the best understanding of the compliance requirements under the Turkish law. As I mentioned, TrustArc anonymity joined forces last November, and we will go forward with a combined platform of privacy solutions. We are currently hard at work in ensuring the integration of the two platforms takes place in the coming months. And we are starting to make sure that the frameworks on which our two platforms are based, that they will be aligned with each other. And that work is close to being finalized. So then we're speaking about Nimity's Privacy Management Accountability Framework that I will talk a bit more about later in the webinar, but also TrustArc's Privacy and Data Governance Framework. On top of that, we will be offering various knowledge solutions. Those will remain under the Nimity brand. And we will also support organizations around the world, both on the operational side and the intelligence side of their privacy and data protection compliance requirements. And then I'm speaking, among other things, about the data inventory, about cookie compliance and web monitoring, but also things like a privacy and risk profile, accountability assessments, and data protection impact assessments. Should you want to know any more about any of these points, feel free to reach out to us after the webinar, and we'd be happy to give you a demonstration. During today's webinar, we won't discuss product. We really want to make sure that you understand the needs under the Turkish Data Protection Act. So the Turkish colleagues will share with you the outlines, the main requirements under the Turkish Data Protection Act, and also explain what you need to do to comply. Also, we will make sure that you can compare the Turkish requirements with the General Data Protection Regulation as it applies in the EU. I'll also take a quick look in comparison with the California Consumer Privacy Act, and we'll tell you more about how to leverage your already existing privacy programs, for example, based on the GDPR for compliance. And of course, there is time for questions at the end of the webinar. Should you have any questions, feel free to use the GoToWebinar control panel. Send us your questions, and then we'll try to give you an answer by the end of the webinar if we are able to, of course, if your questions aren't too complex to discuss in a couple of minutes. Also good to note is that this webinar is being recorded for postponed viewing purposes. The recording plus a copy of the slides will be sent to all participants in the coming week, and you will be able then also to watch the webinar again on our website or to share it with colleagues who haven't been able to join today. So let's take a look at the Turkish Data Protection Act itself. Let's hear more about the content of the law that, as I mentioned, has been in force since 2016. Bora, I believe you are going to start us off with a background on the timeline. So the floor is yours.
Sure, Paul. Thank you. As Paul indicated, the Turkish data protection legislation was enacted in 2016. So although it is a relatively new legislation, it has been around for a while now. Generally speaking, in an effort to harmonize the Turkish legislations with regulations with EU legislations, our certain legal texts are closely modeled after their EU counterparts. And the data protection privacy legislation in Turkey is one of them. But unfortunately, it's modeled after the previous directive rather than the GDPR. The Data Protection Act foresees or foresaw a transition period of 2 years following its enactment, during which the companies were expected to assess and amend their data processing activities for them to be in line with the law. And the deadline for that has passed on April 2018. So in fact, if a company is not complying with the requirements of the law today, it is violating Turkish data protection laws. Apart from the usual compliance requirements like having disclosure statements, policy and procedures, and etc., the law foresees a separate deadline for registration of data controllers to a public registry called Verbis. I will give brief information about Verbis and the requirements of Verbis in later slides. But for now, the deadline for registration to Verbis was originally September 2019. And first, the authority had extended the deadline to December 2019. And last month, in the final days of the year, we got the second extension to June 2020. Given that this is the second time they are extending the deadline, we do not expect any further extensions. And finally, the fine for violating the registration requirement ranges between 5,000 euros and 275,000 euros. Next slide, please.
Thanks, Laura. And I think Haki will now take us through the comparisons of the Turkish data protection law and the GDPR, both the similarities, but also, most importantly, I guess, the differences in the two laws.
Yep. Thanks, Paul. Yes, I think we just thought that it would be useful to give a bit of context and background to our guests who might have GDPR experience, but who do not necessarily have much experience on the Turkish law. As Bora just mentioned, the law itself is modeled after the pre-GDPR law in the EU, which is Directive 95/46. And when considering that, I think what this means that on balance, I believe there are more similarities between the Turkish law and the EU data protection regime than there are differences. So, for example, if you look at core definitions, personal data to start with, the definition of personal data is almost identical to the definition of personal data under the directive, and which makes it very similar to the definition under the GDPR. So it is defined very broadly. And similarly, again, when you look at the definition of controller and processor, they are almost identical as well. So the Turkish law also draws a distinction between data controllers and processors in the same way the GDPR does. So the nature of your organization's obligations will depend on whether you are qualifying as a controller or a processor. But there is one material difference, I think, in terms of definitions that is worth mentioning, which is that the Turkish law does not contain any such term as joint controllership. I think Bora will discuss this later, but what I can say is since there's no joint controllership, I think this is one issue that we do not need to really be concerned about, and it can come as a relief given how complicated this particular area of EU law has become.
Absolutely.
So this is a relief. And in terms of notice and consent, so the obligation to provide privacy notices, it is very similar to the GDPR, but the language that needs to be included in the privacy notices are not identical to the ones to what is required under Articles 13 and 14 of the GDPR. So the Turkish Data Protection Authority is very clear in that a privacy notice drafted under GDPR is not a solution under the Turkish law. So you need to draft a specific Turkish law compliant privacy notice to comply with the Turkish law. Consent is another area which is similar, although the law itself is modeled after directive, the interpretation of the consent requirement is very similar to that of the GDPR. So the consent is defined very similarly. It needs to be specific, freely given, and informed. And in practice, it is very difficult to obtain, but in a way, it is very easy to lose. Individuals can withdraw consents at any time, and consents cannot be obtained in a blanket fashion within privacy notices. So if we move to the next slide, I will discuss the non-special category data and data security later on, but I think it is worth mentioning the differences before that. In terms of scope, I think one of the most significant differences under Turkish law is that there is no provision in Turkish law which clarifies when and which companies the Turkish law will apply to. So as we all know all of us who have dealt with GDPR most probably know, there is Article 3 in GDPR, which states that the GDPR applies to organizations that are established in the EU, or if they are not established in the EU, the GDPR applies if they are offering goods or services to EU individuals or monitor EU individuals' behaviors. So there's no such clarification in the Turkish law. And this, I think, when you look at this silence for me and many other practitioners in Turkey suggests that if your organization is processing personal data of Turkish individuals, then the presumption should be that the Turkish law is applicable, irrespective of where the processing takes place or of the circumstances in which the processing takes place. And the Turkish authority actually provided some guidance on this. For example, in the context of data breaches, they said that the Turkish law would apply if the data breach affects Turkish residents and if data subjects are benefiting from the products and goods within Turkey. But I don't think they have made up their mind as to when the law will apply in many cases. For example, they just, as recently as September 2019, in a decision regarding a data breach that happened at Facebook, the authority stated in its decision, suggested that Facebook is responsible for the breach of personal data belonging to approximately 300,000 people who were using Facebook in Turkish. So the standard there was people who were using Facebook in Turkish, and the standard was not whether that service was being provided in Turkey or to individuals who are residing in Turkey. So someone who is using Facebook, for example, myself, I'm a resident of the UK, and I am using Facebook in Turkish. Would that mean that Facebook should apply Turkish law to me as well, even though that service is being provided in the UK? So when you look at the law, this is an area which I think is very unclear, especially in comparison to what the GDPR says. And it's an area that needs to be monitored very closely. And I think Kaan will also be touching on practical implications of this uncertainty when he is talking about the registration requirement. I will not be talking about the other issues on the slide, for example, processing of special category data, cross-border data transfers, registration, data breach obligations, penalties, because we thought each of these areas deserves their own separate sections. So I will be stopping here.
Okay, thank you very much, Haki. And I see already quite some questions coming in. We'll address those at the end of the webinar. So new laws also means new compliance requirements. What is it that you need to do? What are all the requirements to be taken into account? Kaan, for that, I'll pass the floor to you.
Yeah. Hi, everyone, again. I just wanted to give you some challenges that we have encountered in Turkey during our compliance projects with our clients. These are some major issues that needs to be noted. First of all, I just wanted to mention about the special categories of personal data. Special categories of personal data definition is similar to the definition of sensitive personal data by GDPR. One difference is also someone's appearance and dressing is considered as special categories of personal data according to Turkish law. We think that such categorization is made to prevent any discrimination that may occur from the possible relation between the appearance or dressing of somebody and his/her religious beliefs. And this is something different from GDPR. And also, contrary to the Turkish Data Protection Law, GDPR lists several exemptions for processing sensitive data. But there's a lack of similar exemptions in Turkish Data Protection Law, and this forces data controllers to obtain explicit consent while processing such kind of data, even if they have other legal basis. For example, according to Turkish law, special categories of personal data can be processed with the explicit consent of data subjects, or it is explicitly foreseen by the law. So there are no other exemptions foreseen in the law. And for the health and sexual life related data, it is more restrict. The purposes of the process is limited. It is like protection of public health, preventing medicine, medical diagnosis, treatment, care services, planning and management of health services, financing of health services, and also not only the purposes are limited, but the one who will process such kind of data is also limited. They are the ones who are under the secrecy commitment, and also the authorized institutions and organizations can process such data. So during our compliance projects, we have this is a big difficulty for the employers in Turkey because this limit creates great obstacles for processing health data of employees. As per Turkish Social Security regulation, employers are obliged to keep records of their employees' health data in a certain level. However, none of these employers are considered as authorized organization by the law, and they cannot process such health data. And the lack of such exemptions in Turkish law leads employers to have the consent of their employees. But you know, consent is not every time legally valid. Considering the relation between the employer and the employee. So such a solution actually is maybe not a solution. This is one of the challenges in Turkish law. If we can proceed to the other slide, there is another important topic in Turkey right now is the cross-border data transfers. Similar to GDPR, personal data may be transferred outside of Turkey either by obtaining the explicit consent of the data subject or by conducting the processing actively based on other legal bases, such as like performance of a contract or legitimate interest. However, in order to transfer the data to another country based on such legal basis, other than consent, this country should be accepted as one of the countries that are that has adequate level of protection for personal data. And Turkish DPA is authorized to announce the adequate countries. However, until now, due to several political reasons, Turkish DPA has not yet announced any country as adequate country. And when we search the DPA's guidelines, they say that every country is inadequate, so you need to follow the other rules in the law in order to be in line with the law. And in this case, we have two options, it seems. to get the explicit consent of the data subjects before transferring the data outside of Turkey, or to obtain approval from the Turkish DPA and sign a confidentiality commitment with the party who you want to send the data. But these options are also problematic because, as I said, explicit consent is not always valid, like the employee-employee relation, or the data subject may withdraw its consent anytime. In this case, if you're a company and if your IT systems are outside of Turkey, or if you are using a cloud service outside of which the data centers are outside of Turkey, in that case, you will be in a situation where there is a risk for your business continuity, because if one of your employees withdraw its consent, then you will not able to keep its data outside of Turkey in your IT systems or in your headquarters. And in other cases, some of the data subjects may not prefer to give you consent. In this case, also, there's a risk of business continuity. And also, if you choose the explicit consent as a legal basis, then when the adequate countries are announced, you will not able to switch your legal basis to other legal basis, and this will be a this will be a problem for the data controller. The other option is to take the DPA's approval, Turkish DPA's approval, but actually we heard that there are, this is not official, but we heard that there are some applications to DPA for cross-border transfers, but they didn't, we haven't heard any official reply to these applications, and we don't know how will be the DPA's decision for such an application. So also this may trigger several risks, and if DPA says you cannot transfer, and then again you need to make an investment in Turkey for IT systems, or your business continuity will be jeopardized. This is therefore we actually recommend our clients to take their own risk, and a risk management approach to this risk can be followed. And for example, this is an interesting decision of Turkish DPA. A company was using Gmail as its email service provider, and Turkish DPA considered this as a cross-border data transfer. And however, they didn't apply an administrative fine to this company, but they announced this publicly. And right now, at the moment, we can there are fines that applied by Turkish DPA, but they didn't apply any fine about this cross-border transfer at the moment.
So basically, the data transfer situation is still very complex, if I understand you correctly, Kaan.
Yeah, this is the most
apart from
complex
explicit consent, there is basically no way to get data out of Turkey.
Yeah, that's right. That's right.
And then it's good to realize that also the other way around, of course, the European Union has not made an assessment yet of the Turkish data protection law to find whether or not it is adequate from the EU perspective. So also from the EU to Turkey, you would still need to make use of any of the traditional transfer instruments like the standard contractual clauses, possibly binding corporate rules. But even then, if you have to have the data flowing back and forth between the two countries, it will become very difficult. So let's hope that the Turkish authorities will quickly decide on a fixed process and a fixed timeline for providing their approval, and including all the requirements, or indeed starting to make some decisions on adequacy level.
Exactly, Paul. I agree with you. This is really a risky situation at the moment. And if you want, we can proceed to the next slide for the differences in the content of information notices. Actually, as Hakkı mentioned, there are some slight differences between the information notice requirements. The legal basis of processing should be separately listed in the information notices, but it is not just mentioning the, it is not sufficient to mention the legal basis. Also, you need to give a reference to the related article of Turkish Data Protection Law. Also, contrary to the GDPR, data controllers do not need to mention retention periods or their retention criteria for each type of data for their information notices in Turkey. And also, there are slight differences in the data subject rights. In Turkey, data portability and access rights are not considered as data subject rights. You know that these rights has been regulated by the GDPR, so they were not also recognized in the previous directive. So, so in parallel with the directive, in Turkey right now, data subjects has no data portability or access rights. And another difference is model clauses. I mean, Turkish Data Protection Board has announced its own model clauses. It is different. It's actually their wordings are different than the wordings of GDPR or European ones. So when you are drafting intercompany agreement or when you are drafting a commitment, confidentiality commitment letter from a party who is resident outside of Turkey, you need to take into consideration these model clauses. And a third one, I didn't show this in my presentation, but it is not a difference, but according to Turkish law, data controllers who are subject to registration to VERVIS, this data registration portal, you need to prepare data inventory, and also you need to prepare and announce internally a data retention and destruction policy, and also you need to prepare and put in the force a data incident response plan internally. You know, in GDPR, this is a part of accountability principle, but in Turkey, these are legal requirements explicitly foreseen by the regulations. And my last slide will be the Turkish DPA's recent activities and enforcements. Paul, can we proceed? If you don't have anything to add, can we proceed?
We can, but before we do, I'm still a bit amazed about the difficulties regarding the cross-border data transfers. You mentioned that there will be model clauses that are being prepared or have been prepared. So if you use those, would then you still need to get the consent of the individual or the consent of the DPA? Or if you implement those cross-border data transfer clauses, would that be sufficient?
Actually, if you have the model clauses, anyhow, you need to get the permission of the DPA. In case of explicit consent of the data subject, you don't need these model clauses, actually.
Okay. So what would be your advice for now for data transfers? Just rely upon explicit consent, or don't try it at all?
Actually, good question and very tricky question, Paul. But in my opinion,
or maybe the one solution that we can't mention, just do it and hope for the best.
Yeah, wait and see. Yeah. This is wait and see is can be an approach, but as I mentioned, maybe a risk management approach would be beneficial here to assess which data and data processing activities are related with this cross-border transfer? Can you limit them, or and preparing due to this accountability principle, you can prepare your documentation and your decision. And also in cases where you can easily get explicit consent from the data subjects, this can be the easiest way, but as I told, it is not the best way to go every time. So for each client and for maybe each data processing activity, it should be considered separately, I would say.
Thank you. So yes, let's take a look at enforcement, because there the THDPA seems already to be quite active.
Right, exactly. I mean, it is interesting, but they are very active. Actually, they have been, Turkish DPA has been established in January 2017. Board is entitled to investigate any violation upon complaint, or ex officio limited with the scope of the breach if board is aware of such breach by itself. So actually, if there is no complaint, they don't take actions if they are not aware of such any breach. So this is something I think positive for the companies who are active in Turkey. The board is actually not obliged to announce all its administrative acts or actions, but they have announced their activity report for 2018, last year. So pursuant to this report, it seems that they have received like 310 applications and finalized 38 of them in 2018. Among these 38 applications, they have ruled to impose penalty of around 1,050,000 euros. So it is not that, they were not active in 2018, but then everything has changed in 2019. Now the board has increased its activities majorly. Although the activity report for 2019 has not been published yet, the board has published summaries of certain inspections and penalties. These penalties are imposed upon violations such as data breach and database leaks, use of public data with other purposes than publication, sending spam messages, etc. And major penalties imposed by the board are the ones imposed to Facebook and Marriott. In one of the Facebook cases, errors occurred in the Facebook API and VUS features, and application developers have merely gained access to user data. And in Marriott case, third parties have gained access to a list of Marriott's guests, including their phone numbers. So these were the highest fines that applied by the Turkish DPA last year. It is around 2,000 K euros. And another interesting issue is board is announcing some of the data breaches in its website and clearly stating the name of the relevant data controller, and this eventually affects the reputation of the such companies. For instance, board prefers several times to announce data breaches that have been reported by several reputable Turkish banks. Additionally, even data controllers report any breach to the board. We have seen that boards still issued administrative fines to such companies due to lack of technical measures or being late for such notification to the DPA. So they are they are quite active last year, and we assume that they will be active for this year also. The maximum penalty amount has updated. It is around 200,000 euros at the moment. But this is the maximum, and the amount of the penalty applied by the board may differ according to the severity of the violation and its effects on the data subjects. Paul, this is the highlights from my side.
Thank you very much, Khan. And now we pass on back to Bora to discuss Verbis and the registration requirements that you will have to comply with if all goes well by 30 June 2020. Because just to confirm, no further extensions, right, Bora?
For now, yes, we can. I mean, it's very likely that there's not going to be any further extensions. This is the second time that they're extending the deadline. So Verbis, what is Verbis? Verbis is a publicly available data registry for data controllers. What needs to be registered to Verbis? Verbis is a simple version of the detailed inventory that the companies are required to have under the law. The detailed inventory contains all data processing activities, data categories, legal grounds, retention periods, etc., data transfers, etc. But for Verbis, the controllers need to register only limited information out of their detailed inventories. And the information that needs to be registered to Verbis should be based on data categories. As I mentioned previously, the deadline for registration has been extended twice. So it's likely that June 2020 will be the last extension. At this point, I should note that the registration requirement is a distinct requirement from having an inventory. So even if you're exempt from registration requirement, you should have a data inventory. You should still have a data inventory. And the registry itself and the registration requirement is a unique feature of the Turkish data protection regime when compared to GDPR. However, we keep hearing rumors that there might be amendments to the law to bring it more in line with GDPR. That said, those amendments, whether they would have an impact on the registration requirement, remains to be seen. If we can move on to the next slide, I might talk about the frequent questions that we get about Verbis registration. As I explained in the previous slide, the registration requirement is for data controllers. So one of the questions that we frequently get is the position of non-Turkish data controllers. And before moving on to the non-Turkish data controllers, I should first of all mention that for local data controllers, there are certain exemptions from the registration requirement. So if you employ less than 50 employees and your balance sheet total is below 25 million Turkish liras, which is approximately 3.8 million euros as of today, you're exempt from the registration requirement. But unfortunately, there are no exemptions for non-Turkish data controllers. So this creates the question, especially for multinational companies that have a subsidiary in Turkey and that share the same data processing and IT infrastructure with their Turkish subsidiary. So we have raised this question or this issue vis-a-vis the Turkish DPA, but currently their position is like we don't have joint controllership under the legislation right now, and therefore both of the subsidiary and its parent are separate data controllers, and both of them needs to be registered separately with the Verbis. And another frequent question that we receive is the status of liaison offices and branch offices in Turkey. So the Turkish legislation requires data controllers to be legal persons, and the separate legal personality of branch offices and liaison offices in Turkey is a controversial subject. However, the DPA resolved this controversy for data protection purposes, and they ruled that regardless of the legal personality of the liaison office or branch office, they can still be data controllers. So if the Turkish liaison office or branch office has any processing activities in Turkey, it also needs to be registered with the WERBIS as of today. Paul, this is all I have for WERBIS and it's the frequent questions that we encounter.
Thank you very much. That is very helpful. And just as a reminder, indeed, organizations doing business in Turkey will need to get that registration up and running in the coming months to make sure that that your data processing in Turkey is legal. Leaving aside for the moment the continued struggle with international data transfer. So you've heard about the highlights of the Turkish Data Protection Act. Of course, there is dozens of detailed elements in the legislation as well. For those, I would refer to the text of the law and to your own counsel or the Council of the People on the call today for further detail. What we try to do is give you a basic understanding of what it is that the Turkish law expects from organizations that want to process personal data, that want to do business in Turkey going forward. And obviously, when you need to comply with legislation, there are many elements that you need to fulfill. Turkey is a member of the Council of Europe, has been contributing also to the development of Convention 108 and Convention 108 Plus, which now also contains an accountability requirement. And that also means that there will be a need to continue to demonstrate compliance to the Turkish authorities, to your business partners in Turkey, to your business partners outside of Turkey, if you're established in Turkey yourself. And I always like to refer back to a quote from the Office of the Privacy Commissioner of Canada and the Office of the Information and Privacy Commissioners of Alberta and British Columbia, who in a joint report spoke about being an accountable organization. And basically they state that you must have in place appropriate policies and procedures, promoting good practices, meeting the requirements of the legislation, and that as a whole, you would need a privacy management program, especially if you are subject to multiple laws around the world, whether that is GDPR, CCPA, the Brazilian law, the Indian law that is coming up, or indeed the Turkish law that we've been discussing today. What you will need is a demonstrable capacity to comply to, at a minimum, with the requirements of those laws, and ideally have a privacy management program at the higher level. And at Nimity and at TrustArc, we have been doing a lot of work in order to help organizations demonstrate their accountability. I think many of you will have seen the Nimity Privacy Management Accountability Framework before, and that framework provides the backbone of a privacy management program. Many of you have been working with it already from a GDPR perspective, have implemented privacy management activities to make sure that you can demonstrate compliance with GDPR, but you can actually leverage that work to also deal with the Turkish Data Protection Act. If you look at the mapping of the Turkish law, you see that at a category level, almost all of the categories that you need to implement for the GDPR, whether that is maintaining a governance structure or maintaining indeed that personal data inventory, developing your privacy policies, all of those are relevant for both the GDPR and the Turkish law. Does that mean that you can copy your GDPR privacy policies one-on-one for the Turkish law? No, as you heard Kaan, Bora, and Haki already say, there are some differences. So you will need to look at the outlines. You will need to look at the delta between the GDPR and the Turkish law, or the other laws on which you have based your privacy program. But there is a lot of work that can be repurposed. And if you have that accountable privacy program set up on the basis of principles, on the basis of privacy management activities, general frameworks, instead of just on the specific principles of the law, you will be able to reuse a lot of that information also to comply with the Turkish legislation. And in the end, it all is about making sure that you can tell the story behind your program, why you have made certain decisions, how you have come to certain conclusions. And as we also heard during the comments on the Turkish law, not everything is crystal clear yet, whether that is on the requirements for consent, when it could be valid, when not, on the requirements for the contracts for international data transfers. In some situations, it is just not clear yet what the expectations of the supervisory authority are. And that also means that at some point you will have to take a decision. This is the way we are going to act for now until the moment we hear otherwise, and then also document that decision to make sure that you can actually start going forward and doing your work. So one accountable program can help you deal with that multitude of requirements and can certainly also help to deal with the Turkish Data Protection Act. And of course, when you already have your GDPR data inventory in place, that can be a massive help to also build the inventory for the Turkish Data Protection Act and then support also your registrations in Verbis. So with about 10 minutes to go, I suggest that we move to the questions. There have been many, many questions, and I see two main concerns from the people listening into the webinar today. The first is related to international data transfers. The second is related to Verbis and the registration. Bora, I'm getting back to you first on the registration in Verbis. Because for a lot of people listening in, it is still not completely clear if they have to register in Verbis or not. Can you confirm that if you are a non-Turkish company doing business in Turkey, that you need to do the registration, and also whether that registration requires a local representative?
Thank you, Paul. Yes, I mean, if you're a data controller, if you process data in Turkey, yes, you need to be registered with Verbis right now. And as for your second question, you need to have a representative, and that can be legal or legal person. And if that's a legal person, it needs to have a contact person registered to Verbis, and that contact person is a real person. That contact person can be an employee of the company.
And that person, I assume, would also need to master the Turkish language, because all communication on Verbis will be in Turkish, right?
Yes, exactly. And Verbis has a kind of web-based interface, so you log into that and you put in the relevant details of your data processing, and it's all in Turkish.
Okay, and this applies to data related both to your customers and your employees?
Exactly.
Okay.
You need to register based on data categories. So depending on the data that you receive from customers and employees, you need to register the data obtained from both of them.
Okay. So yes, the threshold is pretty low if you are not established in Turkey and you do business in Turkey, even if you are from outside, even if you're just having your website in Turkey, but processing personal data, you will likely have to register and you need that local representative. Very good to know. Thank you for that. Kaan, coming back to the international data transfers, do you expect that things like binding corporate rules will be accepted for cross-border transfers in the future?
Paul, actually, Turkish DPA is at the moment working on that. At the moment, it is not. They are not accepting binding corporate rules, but they are working on it as far as we heard it. And actually, due to this adequate country issue, this will be a good solution for the international companies who has activities in Turkey, actually, and we are expecting such a decision of the board within 2020.
Okay, so at least there is hopefully light at the end of the tunnel. Another question that came in that I must say I also don't see an easy way out, but how can companies use common IT solutions such as Salesforce or HR systems at the moment?
This is what we encounter in most of the global companies. They are using this kind of platforms which all the countries can access and access to the data. This is a cross-border transfer, and most of them are also the HR departments are in a matrix management organization. They are reporting to the regional HR departments or managers or the head of the HR in the headquarters. And also in these cases, they can be the data controllers also. That's why we need what we recommend to our clients is first of all we need to assess whether the headquarters or their regional management is the companies, group companies, other group companies are data controllers in that case, or if they are just data processors in this case who are providing these systems. They need to assess this, and if it's a cross-border data transfer, then they need to get the consent of the data subject. For the employees, that consent is not so valid in my opinion. Mm-hmm. And DPA's approval is a second option, but it seems that it doesn't work right now in Turkey. So again, at the moment, most of the companies, unfortunately, still using these applications and wait and see approach. Most of them are using wait and see approach, or they are trying to get consent from their employees. These are the two options at the moment, I would say, Paul.
Thank you. Appreciate your honesty. Haki, the next question I think is for you. Does pseudonymized data, especially pseudonymized research data, would that be considered as personal data under the Turkish Act or by the DPA?
Hi, Paul. Yes, I think the definition of personal data is very similar. In under GDPR, pseudonymized data is personal data. So given that the Turkish Data Protection Authority follows the EU definition, the interpretation of the EU definition of personal data very closely, we should presume that pseudonymized data is personal data to the extent an individual can be identified or is identifiable from that data. But just to mention, there's no definition of pseudonymization under Turkish law.
Okay, thank you for that. And maybe, Bora, final question for you, because we are quickly running out of time. What about the enforcement strategy of the Turkish DPA? Do they only work on the basis of complaints? Are they proactively selecting data controllers and processors to inspect? And if so, are they just coming from Verbis, or can they go anywhere?
Right now, they are not doing it proactively. They are doing reactively, and they are only responding, as far as we can see, they're only responding to complaints that they receive. But as I told you, Verbis registration is a requirement, and they would be able to see whether you're exempt from Verbis registration or not, because they are in close connection with tax authorities, so that they can get your balance sheets, and they are in close connection with Social Security institutions, so that they can get your number of employees. So after the registration deadline has passed, they might switch to a more proactive approach, especially for various registrations.
So that is what we can indeed expect for the second half of 2020. Well, that wraps up the time that we have today. Thank you very much for listening in. I know we haven't been able to answer all of your questions, and certainly we have not able to give you satisfactory answers to all of the questions, especially in relation to international transfers. If you would like to learn more how TrustArc Anonymity can help you deal with compliance in Turkey or in other jurisdictions, please reach out to us via the information on screen. And if you require further legal information on the Turkish legislation, please reach out to the lawyers you heard today, either at BASEAC or at Dentons. They work together, so please reach out to them directly. We will take another look also at the questions that we received and see where we will be able to provide an answer to you in writing. Just so you know, we are working on the webinar schedule for TrustArc for the remainder of 2020. There will be many more webinars to come. And in any case, also the quarterly updates that you are used to from Nimity, whether that is on the European Union, on the United States, or other regions, they will come back shortly. So keep track of our website if you would like to be informed on webinar updates. For now, teşekkür ederim. Thank you very much for attending the webinar today, and have a great rest of your day.
If you're a data protection or privacy professional, you already know the pressure: non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on Nimity research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.